In this episode, I would like to discuss about one important section of the Indian Contract Act 1872, that is the undue influence. Section 16 of the Indian Contract Act defines the word undue influence. Now, what it is, that means what is the meaning of undue influence, what are its ingredients, and ultimately what is the impact of undue influence on the contract. That means, if any agreement is induced by exercise of undue influence, what will be the legal consequence? That means whether the agreement will be considered as void or voidable or valid. That is the topic of discussion today. Section 16 of the Indian Contract Act defines the term undue influence. According to section 16, a contract is said to be induced by undue influence if the relations between the parties in the contract subsisting in such a manner that one of the party is in a dominating position over the other, and not only that, he uses that position over the other to gain some unfair advantage over the agreement. So, section 16 of the Indian Contract Act specifies particularly two ingredients of undue influence. First is that one of the party is in a dominating position, and not only that, the second ingredient says that he has used such position over the other to gain some unfair advantage over the agreement. So, if these two ingredients are fulfilled, then we can say that this is the exercise of undue influence. So, let us have a look that section 16 of the Indian Contract Act defines the term undue influence. Now, what are the ingredients? Two ingredients are there, as I have said. The first is one party is in dominating position. So, one party is in dominating position, and second uses that position to obtain unfair advantage. So, if these two ingredients are satisfied, then we can say that the agreement is induced by exercise of undue influence. Now, I would like to discuss about the first ingredient of the undue influence, that is, what is the meaning of dominating position and what are the factors connected with this dominating position. So, dominating position means that when one person is holding some real or apparent authority over the other, or he stands in a fiduciary relationship, or where he has entered into a contract with someone else whose mental capacity is either permanently or temporarily affected by reason of age, illness, or mental or bodily distress. So, if either of these ingredients are satisfied, then we can say that the agreement is entered into by some person and one of him is in a dominating position. So, let us have a look that regarding the first ingredient, that is dominating position concerns with the following factors, like having real or apparent authority, second is having the fiduciary relationship, and third is mental capacity of a contracting party is affected either by age, illness, mental distress or bodily distress. So, these ingredients or factors are connected with the first ingredient, that is the dominating position. Now, I am discussing about two illustrations as prescribed by section 16 of the Indian Contract Act. The first one is this, that one agreement is entered by father with his minor son, and what money was advanced to the son by the father, after attaining the age of majority, he has executed a bond. That means, he has obtained a bond from the son and showing there that much more greater amount of money which was not actually paid. So, ultimately the son was supposed to pay a particular money, but the bond was executed by exercising the undue influence by the father, and where the son had to agree to pay a much more greater amount, that is the exercise of undue influence. And another illustration stated that a patient is enfeebled by disease and his medical attendant, that means who is taking the care of treatment of that patient, taking the advantage of his age or illness, he is pressurizing that person to forward the much more medical expenditure, that means unreasonable expenditure he is asking from the patient. So, that is also the exercise of undue influence. So, what can be said that if any patient is admitted to the hospital and later on taking the advantage of his age or illness, if the hospital authority or the doctor claims some money, means which is unreasonable. So, that is the clear case of undue influence. So, let us have a look. The first ingredient is, that is A and B, that is father and minor son. So, father here is having the dominating position, and not only that, he used that position to gain some unfair advantage over the agreement. And second, as I have said, that A is the patient and B is the medical attendant and having dominating position and use that position for unfair gain. So, in both illustrations as prescribed by the Indian Contract Act section 16 itself, it is the case of undue influence. Now, I would like to discuss about the first ingredient of dominating position, that is what is the significance of real or apparent authority. Now, first I am concerned with the real authority. It means that if the situation is such that two contracting party, that one of having a real authority over the other, that means it can be perceived from the prima facie. That means from the first sight we can understand that there is existing the real authority of one upon the other. Some examples I can cite, like a relationship between the employer and employee. Employee is acting under the employer, so obviously employer is in the dominating position and he caused the employee to enter into an agreement and ultimately took the unfair advantage. That means he asked the employee to hand over him his some commodity and ultimately make the underpayment, means has not given the actual price. So, that is the illustration of exercise of undue influence. Or another example can be given, like if the agreement is made between the income tax officer and the assessee. Income tax officer is causing any assessee to enter into an agreement with him, and ultimately a condition is given that unless you sign the paper or unless you agree upon the terms of the agreement, I will impose a huge penalty against you. So, this type of cases are coming under the purview of undue influence. Another example is like if the agreement is made between the police officer and the prisoner. So, police officer is in the dominating position and he used the position over the other. Maybe it may be the prisoner or maybe the subordinate person, means the subordinate constable. He compelled him to agree into the terms of the agreement and ultimately thereby gain some unfair advantage. So, that is the clear case of undue influence. And another is like a relationship between the doctor and the patient. When the patient is admitted, their family members all are very much in pressure, because at that point of time their ultimate aim is to give the relief to the patient, and the doctor and hospital authority, they take the advantage of that situation and they are claiming the huge money, unreasonable money from the family of the patient. So, these are all clear illustrations of the undue influence. So, let us have a look that dominating position concerned with the factor, that is first is the real authority, means employer and employee, as I have stated, income tax officer or assessee, police officer or prisoner, and doctor and the patient. I have given the tick mark. So, these are the persons who are in the dominating position: employer, income tax officer, police officer, doctor. They are the holding the dominating position in these circumstances. So, it does not mean that the agreement not at all can be entered into between the income tax officer or assessee or police officer or prisoner. Agreement can be made, but the condition is that they must not exercise such position for gaining some unfair advantage over the agreement. If they do, then the agreement will not be said as valid, or what will be the consequences I will discuss later on, but this will be considered that dominating position is exercised, because here this is the position of the real authority. One person is having the real authority over the other. Now, I am citing one decision of Allahabad High Court of the year 1890, that is Mannu Singh versus Umadat Pandey. It is a case relating to the dominating position, how exercised. So, in this case, in a brief manner, that is, one spiritual guru asked his disciple to give the entire property to him, so that he will get the benefit in the next world, that is after his death. So, that will be the for emancipation of his soul, and that is the clear case of undue influence. Court decided that the spiritual guru asked his devotee to gift entire property in his favor in order to gain the emancipation of the devotee in the next world, that means after his death. So, here guru is having the real or apparent authority, and not only that, he used it over his disciple or devotee to gain some unfair advantage in the agreement. So, let us have a look that real or apparent authority related case, that is Mannu Singh versus Umadat Pandey 1890 Allahabad. So, it was decided that the agreement is entered between guru and disciple or devotee, and where the Guruji exercised this undue influence. Now, I am discussing about another ingredient, that is fiduciary relationship of the dominating position. So, fiduciary relationship means the relationship which is based on the confidence or trust. Some examples like the relationship between the lawyer and client, father and son, or doctor and patient. So, whatever the relationship existing between the lawyer and client, that is a kind of fiduciary relationship, because client are disclosing various personal informations, secrets before the lawyer. So, that means a kind of fiduciary relationship, that lawyer is not supposed to disclose those information to someone else, because these are kept to be in secret. And not only that, so far Indian Evidence Act 1872 is concerned. So, there are two sections relating to this, like section 126, that is lawyer cannot be compelled to disclose the informations of the client. That means communication made between the lawyer and client is protected from disclosure. And not only that, by virtue of section 129 of the Evidence Act, no person also can be compelled in any court to disclose what advice he has got from the lawyer. So, these are also protected from disclosure by virtue of the Evidence Act. So, apparent or real authority may be between the doctor and patient. Doctor knows personal secrets of the patient, and it may be between the father and son, because father knows everything of the child. So, these are the examples of the fiduciary relationship, that is based on the relationship based on trust or confidence. That is the fiduciary relationship, like as I have discussed, that lawyer and client, and according to Indian Evidence Act section 126 and 129, as I have discussed, are concerned with this fiduciary relationship. And father and son, and doctor and patient. So, these are very much essential ingredient for dominating position, and court will consider that whether there is the fiduciary relationship or not. Now, I would like to discuss about the term mental distress as explained in the section 16 of the Contract Act. So, mental distress means if any person's mental capacity is affected either temporarily or permanently by reason of age, illness, infirmity or various other reasons, that means he cannot understand the nature and consequence of his act, whether it is right or whether it is wrong. So, in this aspect I would like to discuss one decisions taken by Madras High Court in the year 1910, that is Ranni Annapurni versus Swaminathan. What happened in this case, that one widow borrowed some money from the moneylender because she required the money to establish her claim for maintenance. So, as way of litigation cost, much money was required, and ultimately the moneylender in this case was in the dominating position, and so he used that position, he exerted all his influence upon the widow, and ultimately he persuaded her to sign into the agreement where it was fixed an exorbitant rate of interest, that is 100%. But ultimately it was decided by the court that the percentage, exorbitant percentage was decided by exercising the undue influence. So, ultimately court reduced such interest from 100% to 24%. So, let us have a look that that is the meaning of mental distress, means that whose mental distress means if the mental capacity is either temporarily or permanently affected by reason of age, illness, etc. And in Ranni Annapurni versus Swaminathan, it was decided by Madras High Court, as I have said, that what happened, that a poor Hindu widow borrowed money at the rate of 100% interest, but ultimately it was reduced to 24% because court decided that it was actually exercise of undue influence. Now, I would like to discuss about whether urgent need of money is considered as distress or not. That means, under what circumstances urgent need of money can be considered as distress or not. So, in the instant case, I want to discuss about one illustration, illustration C given in section 16 itself. That is, if any borrower enters into a fresh loan agreement with the moneylender and there appears to be some unconscionable terms and conditions, that means an exorbitant rate of interest is charged by the moneylender against the borrower. So, that means the borrower in this case, as illustration given, that Mr. A is indebted to B already. Now, A entered into a fresh agreement with B where B has imposed an exorbitant rate of interest, and in this case it appears to before the court of law that it is unconscionable, that means irrational. So, in that case it is the burden of proof on the part of the moneylender, that is B, to prove it that the contract was not entered into by practicing the undue influence. So, there is a case similarly like the illustration C of section 16, that is Dialaram versus Sarga, AIR 1927. In this case also the fresh agreement was entered between the borrower and the moneylender, where it was stipulated, agreed upon that apart from paying the money at an exorbitant rate of interest, additionally the borrower is to return the much more quantity of wheat. So, that is appearing before the court of law as unconscionable. So, in this case also the burden of proof that the contract was not induced by exercise of undue influences on the part of the moneylender. So, let us have a look that according to illustration C, that when urgent need of money is no distress. So, here A and B, as I have stated, A is here the borrower and B is the money lender, and here some unconscionable terms was there. So, it is on the part of burden of proof is on B, that is the money lender, when it appears that some unconscionable terms made in the fresh agreement. So, it is on the part of the money lender to prove that it was not induced by exercise of undue influence. So, similarly, the case I have already discussed, that is Dialaram versus Sarga, AIR 1927, that here also exactly the same situation like illustration C of the Contract Act. So, unconscionable terms appears. So, burden of proof, absence of undue influence is on the money lender. So, this judgment Dialaram and Sarga is exactly similar to illustration C of section 16. So, where it appears that the terms of the agreement which is freshly made is unconscionable. So, burden of proof is on the person, that means who is in the dominating position. So, money lender is to prove that it was not induced by undue influence. Now, I would like to discuss about illustration D of section 16, where there is no exercise of undue influence, though there was an illustration. According to the illustration, an exorbitant rate of interest was charged. So, according to illustration D of section 16, that Mr. A borrowed some money from the banker at an exorbitant rate of interest during the time of the stringency in the market. Stringency in market means money market. Stringency of money market means when the money is not easily available by way of loan. So, A entered into an agreement with the banker and borrowed the money, and an exorbitant rate of interest was charged by the banker, and that was the prior condition for sanctioning the loan, and A entered into such agreement. But that is not considered as exercise of undue influence, because that is the ordinary course of business. So, in this situation, though exorbitant rate of interest was charged by the banker, but it will not be considered as exercise of undue influence, since it is by nature the ordinary course of business. So, let us have a look that in the illustration D, A applies loan to banker in time of stringency in market and high rate of interest was charged, and transaction is in ordinary course of business. So, it is not induced by undue influence. So, that is the difference between illustration C and D. In the earlier case, as I have stated earlier, there is the presumption on the part of the money lender to prove that there was no exercise of undue influence, but in the instant problem it is not exercise of undue influence. Now, I would like to discuss about whether statutory compulsion will be considered as exercise of undue influence or not. So, in this aspect I would like to discuss one prominent judgment of our apex court, that is Andhra Sugars Limited versus State of Andhra Pradesh, decided in the year 1968, where section 21 of the Andhra Pradesh Sugarcane Regulation of Supply and Purchase Act 1961 was challenged. So, the impugned section was section 21. By virtue of this section, the grower of the sugarcane had the freedom to offer for sale his produce to the nearest factory owner, and if the factory owner is being offered by the cultivator, means the sugarcane grower, he could not refuse it. That means that was the statutory compulsion, that if he is being offered for purchase, he is to purchase it, he cannot deny it. So, whether this is the violative of section 16 was challenged before the court of law, but court said that statutory compulsion is not considered as exercise of the undue influence. So, in this case, that is Andhra Sugars Limited versus State of AP, AIR 1968, as I have stated, that section 21 of the Andhra Pradesh Sugarcane Regulation of Supply and Purchase Act 1961 was challenged, where it was decided by the court that statutory compulsion is not considered as the exercise of undue influence. Now let me discuss about what is the position of law relating to the presumption of the undue influence. That means when exercise of undue influence can be presumed. So if in any contract it is shown that one of the parties in the dominating position, then court will presume that there was exercise of the undue influence. So that means if once it is shown that the defendant is holding any dominating position, then it will be presumed by the court of law that there was exercise of the undue influence. So it is the burden of proof on the part of the defendant now to prove it beyond reasonable doubt that the consent came out freely. That means the plaintiff was not induced by exercise of the undue influence. So presumption of law, it is the part of the Evidence Act, Indian Evidence Act 1872. So in this case court will presume it unless contrary is proved by the defendant. So if what is the presumption of the undue influence, that is if the dominating position is shown, then the presumption of exercise of undue influence, and then burden of proof on the defendant that consent was freely given. So if once the dominating position is established, then court will presume that there is certainly the exercise of undue influence. Then defendant has to prove the contrary situation, that means the plaintiff consented freely. Now let me discuss about the significance of subsection 3 of section 16, which says that if in a contract it appears to be that there is something unconscionable in the agreement, means something irrational or something unfair, and it is proved that one of the party is in the dominating position, then it is the burden of proof of the person who is in the dominating position to prove it beyond reasonable doubt that there was no exercise of undue influence. That means consent has come out voluntarily. So that means if the contract is made between the two parties and it is apparently shown that one of the party is in the dominating position and there is something irrational or unconscionable things happen, then court will presume that there is the exercise of undue influence. Then it is the burden of proof on the person who is in the dominating position to prove it that there was no exercise of undue influence, but consent came out freely. That means subsection 3, that is the meaning of unconscionableness, that if one party is in a dominating position and if the contract is apparently unconscionable or unfair, the law presumes exercise of undue influence. So law will presume it as per the Indian Evidence Act law of presumption, but contrary can be proved by the defendant. Now I would like to discuss about subsection 3 of section 16, which says that if any person who is in a dominating position enters into a contract with some other person and the transaction appears on the face to be unconscionable, or on the evidence adduced it appears to be unconscionable, then court shall presume that there is the exercise of undue influence, and the burden of proof that such contract was not induced by undue influence is on the person who is in the dominating position. So that means if something unconscionable or irrational is there prima facie, means from the first sight that there is something unconscionable or irrelevant or something unfair and one of the party is in a dominating position, then court will presume it in pursuance of the law of presumption of Indian Evidence Act 1872 that there is the exercise of undue influence. That means the other party has not consented freely, but then it is the burden of proof on the person who was in the dominant position that there was no exercise of undue influence. That means the other party has consented freely. So what are the ingredients of subsection 3 of section 16? That is the meaning of unconscionableness. That means if one party is in a dominating position and if the contract is apparently unconscionable or unfair, and then the law presumes exercise of undue influence. So court will presume it that there is the exercise of undue influence, but maybe that other party has consented freely, but that is the burden of proof on the person who who is in the dominating position. Now I am discussing about in a short manner that what is the consequence of a contract if entered by a Pardanosin woman. Pardanosin woman means the woman who is not appearing publicly, that means who is behind the curtain. So she has entered into a contract. Now what will be the consequence? Now according to section 16, undue influence means if any Pardanosin woman enters into a contract with someone else, then court will presume that there is the exercise of undue influence unless the other party can prove it that such consent given voluntarily or freely. That means the lady has understood the nature and consequence of his act and then she consented in it. So unless it is proved by the other side, then court will presume that there is the exercise of undue influence if any contract entered upon by any Pardanosin woman. So that is why, so contract with Pardanosin woman means it is presumed to be made by undue influence unless the other party can show the voluntary act of such woman. So unless the voluntary conduct is proved by the other side, court will presume that there is the exercise of undue influence. That is the position of the contract entered by any Pardanosin woman. Now I would like to discuss about the end portion of section 16, that is subsection 3 of section 16. At the end portion it is said that nothing in this subsection shall affect the operation of section 111 of the Indian Evidence Act 1872. And section 111 of the Indian Evidence Act says about the good faith of the transaction between the persons, one of whom when is in the position of active confidence. So if any person is in the active confidence in any agreement, when any agreement is entered between few persons, one of whom is in the active confidence, then the burden of proof, that is the agreement was entered by good faith, is on the person who is in the active confidence. So if the agreement is such that one has entered into with the other and one is holding the active confidence upon the other, then the burden of proof that such agreement was entered by the other side in good faith is on the person who is in the active confidence. So it is stated there that nothing in subsection 3 of subsection 3 shall affect the provisions of section 111 of the Indian Evidence Act 1872. And section 111 of the Indian Evidence Act 1872 says that proof of good faith in transactions where one party is in relation of active confidence. So section 111 says so, and two illustrations are also prescribed in section 111 itself. The first is that when any sale is actually made by a client to any attorney. So attorney or advocate is in the active confidence. So the burden of proof in that case, if there is any suit filed by the client against the attorney and where there is the question that whether there is exercise of good faith or not, it is the burden of proof on the part of the attorney or advocate that there was the good faith of the transaction. And similarly, in a suit made between the son and father, son has filed the suit against the father. Actually, son was minor, just coming in age, that becoming the major, he sold out the property to the father, and there was some dispute. The suit is filed by the son against the father, and there is the question of whether there is exercise of good faith or not. Now similarly, here the burden of proof that the contract was made by exercising good faith by the son is upon father. So that is why two illustrations are given in section 111 of the Evidence Act itself. The first is that sale by client to an attorney, that is burden of proof is upon the attorney, and similarly that sale by a son just coming of age to his father, that is burden of proof on the father. So in this case the burden of proof is on the attorney, and in this case in the father, because both attorney and father both are there in the active confidence. Now I am discussing about the consequence of exercise of undue influence in any contract. According to section 19A of the Indian Contract Act, if any contract is induced by exercise of undue influence, then it is voidable at the option of the party whose consent was so thereby caused. That means it is not absolutely void, that means void ab initio, but it is voidable at the option of the party whose consent was so thereby caused. So, it is stated in section 19A that it may be absolutely void, or if any party has gained some benefit in such contract, then on such terms and conditions as court think fit proper. And there are two illustrations mentioned in the section 19A which discusses about the situations. Now, I am discussing about the section at first, that is the power, section 19A, that is power to set aside contract induced by undue influence. So, it is voidable at the option of the party whose consent was so caused, and it may be set aside either absolutely, or if any party has received any benefit, then upon such terms. Now, let me discuss the two illustrations mentioned in section 19A itself. Illustration A of section 19A says that A's son has forged the name of B, and so B thereby threatens A that he will prosecute against his son unless he sign A in a bond, and ultimately A has signed in the bond, being threatened by B that his son will be prosecuted since he has forged B's name. So, bond was executed by A. Now, if B files a suit for recovering anything upon such bond, court may set aside such bond because there is the exercise of undue influence, because that bond was not signed by A with free consent. And second illustration is similar. It is stated that a money lender forwarded some money rupees 100 to an agriculturist, and later on by exercising undue influence obtained a bond from that agriculturist to the tune of rupees 200 and along with the interest of 6% per month. Then court may set aside the bond, but with the condition that agriculturist is to reimburse 100 rupees along with the reasonable interest, because in this case the agriculturist actually has obtained rupees 100. So, that means that money is to be restored along with the reasonable rate of interest. That means it will not be set aside entirely, but with the conditions as the court thinks reasonable. So, illustration as I have stated said that a son has forged B's name to a promissory note, and B under threat of prosecuting a son obtains a bond from A, and if B sues on that bond, then court may set aside it. And B illustration that A money lender advances rupees 100 to B, an agriculturist, and A induces by undue influence to B to execute a bond for rupees 200 with interest at 6% per month. Court may set aside the bond, ordering B to repay rupees 100 with some interest. So, this is the concept of undue influence. If it is proved, then certainly it will be presumed by the court of law that the consent is not made voluntarily, and if the contract in which the consent is not voluntarily made, in case of exercising the undue influence, the effect or consequence is already discussed, that will be followed in pursuance of section 19A of the Indian Contract Act. So, section 16 and 19A, these are the relevant provisions where there is the exercise of undue influence.